Let's see, so I've been starting some of my talks lately with this question. Well, actually, a few questions. Some of you are practicing lawyers, yeah? Not all students. How many of you still think I'm chief disciplinary counsel? No, Judge Gandhi, you know better. Right, so I'm not, and have not been for 3 years, so this is a safe zone to talk. That's the first thing. Then the second thing is, some of this is going to be back to Ethics 101. And so when I ask questions, it's no fair for you guys. If you already heard this, for the rest of you, it might be a little basic sometimes. For some of you, it's going to be painful. Think of it sort of as a visit to your dentist. It's going to be about an hour worth of pain. And then it'll be over with, and you'll go on with your life, and it'll be not as bad as you thought it was. What Chanel was kind enough to ask me to come and do is to talk to you some about ethical issues related to the New Mexico Civil Rights Act. Here's a big shock that you probably have heard all day today, which is there's not a lot of law yet around the New Mexico Civil Rights Act. The question of what the ethical issues are is a little bit challenging, and so we'll see how we get through it together. This will go much better if you ask questions, and that doesn't give you guys, the law students, I can always count on. And so I told you some of this would be basic. We're going to start with sort of the big. How many of you spent last night looking at the rules of professional conduct? None of you. See? What I am doing is still related to the world of ethics. And I'm working for the State Bar of New Mexico. I do the Professional Development Program, which is law practice management, and I'm also their ethics counsel. So I still spend a fair amount of time thinking about the rules of professional conduct. And the law school is, some I'd say kind enough, some might say foolish enough to still let me teach ethics here. These are topics that I do spend at least a little bit of time thinking about. And one of the topics I think about to start with is a really basic concept that I think not law students so much struggle with, but I think lawyers struggle with. So if you're trying to make a decision as to Civil Rights Act, under federal law, the New Mexico Civil Rights Act, the New Mexico Tort Claims Act, whose decision is that? First off, let's go back to 16102. Who remembers 16102 besides Maureen Sanders? Yeah? Good. What is 16102? Scope of representation. So you must have had a really good ethics professor. 16102, scope of representation. And if you took it at its most simplistic, basic, the way most lawyers think about it, what does 16102 say? Yeah, so a client makes decisions on substance, right? And most lawyers think of it as lawyers make decisions on strategy. So if you're trying to decide Federal Civil Rights Act, New Mexico Civil Rights Act, New Mexico Tort Claims Act, strategy, substance, what do you think? Both? In what sense? It seems really strategic to me, based on just what little bit I've heard recently. I saw a thumbs up, so you're thinking pure strategy. By the way, there are no wrong answers.
I would say strategy because why would the client have the information to judge which vehicle is the best for their
right? So you guys have spent most of the day talking about how does the New Mexico Civil Rights Act work, what's the legislative intent behind it. I just heard 4 people talking about whether or not there's a negligence standard, whether there's intent, right? And you guys are all trained in the law, right? So how's a client coming in to know whether or not one act for them is better than the other, both acts, maybe they should try all 3? That sounds a lot like client stuff. I mean, like lawyer stuff, right? Strategy. What do you think? You two who are sitting there together, Judge Vanzi and Maureen Sanders. Strategy? Yes.
I'm thinking that you're crazy as a lawyer if you don't try to explain it a little bit to your client, especially if you're giving up like punitive damages because you're not going to federal court. Because if they go and talk to another lawyer, they say, well, why aren't you asking for punitive damages? Or why did you only get $28,000? You should have gotten punitive damages. So you got to be careful about that.
And I think that's exactly right. And so I think what Maureen Sanders is saying, and of course she can cheat a little because she's also taught ethics, right? Is under 16102, yeah, there's that question about lawyers get to decide strategy, clients get to decide substance. I think your point is very well taken back behind Maureen, that how are clients to know, right? It's sort of like asking a client, do I need an expert, do I not need a client? I don't have any idea, right? Except there are some real substantive rights associated with each of those acts, and some are the same, right, and some are different. And those differences particularly mean that I think you're going to have some conversation with the client for a couple of reasons, right? So the first reason is just because the client gets to make decisions on the substance, and some of those substantive rights, things like punitive damages, are substantive. That affects, at the end of the day, what the client's decision should be, shouldn't be, right? And then some of it has to do with more, what I'd say is enlightened thinking about how lawyers are supposed to act, right? So the law school has spent the last 4 or 5 years with a newer class. It's called Lab. Have any of you heard of Lab, besides those law students who took it? No, you guys, you can raise your hand too, that's fine. So Lab is built around a couple of things, right? Part of it is to give law students sort of a hands-on approach to what being a lawyer is like. So they get to do some negotiation, they get to do some client counseling. And the client counseling in particular is what I'm interested in talking about, because if you start looking at the literature related to that sort of artificial distinction between substance and strategy, really there's a big blur, and in fact there's much more in the literature now lean towards, it's called the joint venture model in some literature, it's called client-centered counseling in most literature. And what it focuses on is including the client in all of the decisions all the way along, particularly those that have even something that might arguably be more strategy, but really has some substantive component to it. So I think that's one of the reasons why Maureen's exactly right. We have to talk about that stuff, right? And then I think the second reason is there's another rule of professional conduct that I think imposes it on them. What do you think that is? Nobody? Come on, I can wait here a long time. By the way, it occurred to me I'm the last person to speak to you today, right? And there's a reception going on soon after this, and so I'm the only thing between you and having fun. You know, I don't think I can go back and change grades for the law students who asked me to come and work on this. 16104, right? 16104 is the communication rule. And the communication rule says that you've got to at least talk to your clients sufficiently to inform them about what they need to know to make smart decisions. And I think they're having to make smart decisions about what law they want to pursue. And so I think you have to explain some things to them. So how many of you are more on the plaintiff side than the defense side? Most of you? Yeah, okay. So most of this, and really I think that's where a lot of the conversation takes place. So this is not an anti-plaintiff, anti-defendant, right? This is really more the pragmatic piece of it, especially as this law is starting to develop. So if we look at 42 U.S. Section 1983, I think you have to talk to your clients about why they might want to take a 42 U.S. 1983 claim. What would be some of the reasons to go that route? What would you think? One of them Maureen touched on, right? Punitive damages. The Mexico tort claim, the Mexico Civil Rights Act has punitive damages or no? No, right? So the client could be giving something up. That could be an advantage. If they go the route of the Civil Rights Act, the Civil Rights Act under federal law. What else? Why else might they want to go that way? What else would you talk about? Way in the back.
I think that your attorney's fees that you can get under the Civil Rights Act are included in the $2 million cap. In federal, they're not. They're separate.
Right, and so what I heard from the person in back is when you're talking to them about the difference between a New Mexico Civil Rights Act and a federal Civil Rights Act is attorney's fees. Now you can get fees under both acts, right? In fact, under the federal Civil Rights Act, it's a little bit different phrasing, right? Any of you can remember that? It's prevailing party. So plaintiffs attorneys can recover. Defense attorneys in theory can recover. I think most of the case law has come out related to defense attorneys that the plaintiff's claim has to be frivolous at the inception. Some defense attorneys are going to complain that that's a tougher standard for them to meet, maybe not. And so what if you look at the intention behind why there are attorney's fees in the Federal Civil Rights Act, it's that private attorney general idea. And so that you incentivize it and make it a little bit an easier path for a plaintiff's attorney is consistent with the legislative history, right? So that probably shouldn't bother anybody terribly. But what's different, right, are two things, right? So one is, under the New Mexico Civil Rights Act, only plaintiff's attorneys are entitled to fees at the discretion of the court, right? So defendants, if any of you do defense work, you are not going to get attorney's fees, even if you can demonstrate some sort of frivolous filing by the plaintiff's attorney. And so if you're on the defense side, one thing I would mention to you is, you should at least talk to your client about that fact. That's not something they're going to recover. They generally don't have a choice as to where the claim is going to be brought, because that's going to be the plaintiff's choice, right? But you touched on the second piece, which is important. In the insurance world, right, when we think of professional liability insurance, sometimes some of you have heard of a Pac-Man policy. Maybe you've heard of that. Yeah, the Pac-Man policy is the idea where the money you spend for the defense attorney in the professional liability claim starts eroding, or for some of those of you who are old enough to remember the old Pac-Man game, right, it starts eating up the coverage. Well, the same thing potentially in the New Mexico Civil Rights Act, right, which is different than the Federal Civil Rights Act. Federal Civil Rights Act, the damages are whatever the damages are. Court awards them, defendant agrees to settle, whatever, right? And then the fees are on top of that. Right? In the New Mexico Civil Rights Act, that's not the case. And not only that, there's a cap in the New Mexico Civil Rights Act, yes? I think it started out at $2 million. And what I should have looked. This is like a lack of competence on my
Now
part.
$2 million including attorney's fees.
No, it's $2 million including fees, but there's an escalator, a COLA escalator, right? Has it gone up?
Yeah.
The COLA has gone up?
I think it's 2.9.
2.9 million? 2.29 million, all right, because it started out at $2 million on January 1 of 2021, and then there's a COLA clause. I think risk management's tasked with publishing that rate, and then it goes up. So now Judge Manzi tells me it's $2.29 million, so it's up a little bit. But it's a Pac-Man, right? It's a Pac-Man in the sense that what's happening is every dollar you, lawyer, spend on the case for your fees, and every dollar you spend on costs comes out of whose pocket? Defendants? Ultimately, it comes out of the plaintiff's pocket, right? Because if there's an award against the defendant, ultimately the total award against the defendant can't exceed that 229, fees and costs included. What does that mean? What does that mean for you as a lawyer? Anybody see any issue? I'm sorry? It creates kind of an adversity. How so?
Just that the investment that you normally is compensated for keeps up their price.
Yeah, absolutely, right? You're eroding, ultimately, their recovery. Now, if you think about the Federal Civil Rights Act, you're going to, and presumably, let me start with an assumption that you are all confident, you're all not going to fall into this trap, right? You're going to do what's necessary for the matter, right? But at least in theory, arguably, under the Federal Civil Rights Act, the lawyer doesn't have to stop for a moment and think about my own interest in it. And we'll talk in a minute about when a lawyer might have to think about their own interest in it, right? But under the New Mexico Civil Rights Act, the lawyer's own recovery is tied to the client's recovery, and it erodes the client's recovery. And that's called something else under the law. Yeah, Bob?
But then the conflict only arises if the recovery for the party is $2 million, 2.0.
If it reaches up near the cap, right?
Yes.
Yeah.
Is that correct? I'm asking.
Well, so here's the issue, and you hit on it, right? It creates a conflict, or at least it creates a potential for a conflict. And what people sometimes forget under 16-107, 16-107 is a concurrent conflict rule. And most people think of concurrent conflicts as, I'm representing more than one person, do they have some adversity between each other, are their interests not aligned? Yeah, that's a 16-107 conflict. But another provision of 16-107 is when the lawyer's own interests are in conflict with the client's best interests. And as the damages start rising up towards the top, right, towards that cap, now you've got the potential for the lawyer's interests to be in conflict with the client's interests, right? Yes?
But only if your agreement is written in such a way that it's not like a pure contingency, for instance.
Only if the agreement's written as pure contingency?
No, written in such a, if your agreement is a pure contingency, for instance, it wouldn't matter if part of your recovery were attorney's fees or not, if the client's still getting the same percentage regardless of whether it's pure recovery or recovery in attorney's fees. In other words, if you write your agreement correctly, the client is going to get the same percentage of the awarded attorney's fees as they are the recovery.
Maybe I'm following you, maybe not. So if there's a limited pot of money,
If there's $2 million,
Yeah.
$1 billion recovery and $1 billion in attorney's fees.
Right.
And the client gets 60% regardless. And if it was $2 million and extra attorney's fees, and it's still got the $2 million, we're still getting 60%, there's no.
well, so you're talking percentage-wise, there's no conflict, but hard dollar-wise, I think, maybe I'm not following you. I think hard dollar-wise, when you get near the top, potentially every dollar that you would take out could be $1 less than the client
No,
takes
but
out.
every dollar you take out, the client gets 60%, 60 cents out.
You're talking in terms of cents on the dollar.
Yes.
Yeah, I think-
Regardless of whether it's peer recovery or attorney's fees, if you write your agreement under a peer contingency, the client gets the same percentage.
If it's written pure contingency, I think maybe that's true, right? So I think it depends on how the fee agreement's written, and we're gonna talk about fee agreements in a second. But I think at least potentially you've got a conflict when you've got a cap. So I think one of the conversations with the client has to be, there's a cap, here's why I'm writing the fee agreement this way, and here's potentially what that conflict could be if we do something else, right? Because I think the client's gonna have to ultimately agree to how you write that fee agreement.
Yeah, and what I'm saying is you write it in such a way that it doesn't matter how the recovery is couched, whether it's peer recovery or recovery of attorney's fees, that they get the same amount regardless.
But the other issue, right, is you're also having to talk to the client about that cap, right? I think you've got to talk to the client in terms of what their actual damages are, because what's the cap on federal civil rights claim? There is no cap, right? And you can get punitive damages, right? Whereas under the New Mexico Civil Rights Act, that's simply not true. Now, for some clients too, and this is based just purely on memory, you guys tell me if this is true or not. Do some of your clients care about the damages? Sure. Do they also care about who the defendants are? Or they don't care? What's been your experience? I'm sorry?
Pretty rare when they really care.
Pretty rare that they care?
Sometimes.
Sometimes they care, right? And why am I raising that? Sometimes, especially for the ones who care. Why do I want to raise that as an issue?
Because they care about that a lot.
Yeah, and what have you heard today that's a difference between?
You can't name individual officers, that means a lot to some people.
Yeah.
They want their name out there.
Especially at least in my experience, so for those of you who knew me before my prior life, right? What I did was civil rights defense. I represented a lot of cops, right? And cops, by and large, didn't like to be sued. But a lot of the plaintiffs had an emotional investment in naming the law enforcement officer who they believed wronged them, right? Now, I think you're right, some clients don't care, right? It's lawyer, name whoever needs to be named. I'm ultimately want some sort of recovery, some sort of justice, whatever, right? And whoever's name is next to that, whatever, right? But at least in terms of law enforcement officers, I think a lot of plaintiffs do care. And by the way, a lot of law enforcement officers care because they don't like to see judgment after their name, right? And so they're caring from the defense side. I think as a defendant, just as an aside, if you're a defense lawyer, you've got to talk to them about, hey, if this is brought under federal civil rights, here's at least one of the risks associated with it. So I think that's another conversation though you have to have with the client, right? Who can we name as a defendant? How important is that to you? What might the effect of that be, right? What about probably the biggest thing, right? At least this is what you hear in the press as to one of the big reasons why the New Mexico Civil Rights Act was pushed and why a lot of states are pushing towards state constitutional protections with their own Civil Rights Act like. Qualified immunity, right? And so I think that's another conversation you're having to have with the client about what that means, and that gets back to your point, right? Which is that's a pretty heady concept for some lawyers, right? Much less for clients, and being able to explain to them what that means in terms that they can understand and relate. I think that's probably incumbent on you under your 16102, your 16104 duties. Ultimately, how do you think you explain that to the client, that qualified immunity issue? Because they're just hearing qualified immunity in their head swimming, and was it clearly established, and right? What it means is what I think you heard at least from the last speaker, which is, hey plaintiff, if we go to federal court under a federal civil rights act, there's this doctrine whereby the defendant can claim that they're not liable because this was not a clearly established violation of rights. And the plaintiff's going to say to you, what the hell does that mean? And you're going to say, Well, it means they're gonna file a motion to try to get this out before we go to trial. Okay, and then, not only that, if they lose, we might be going up to Denver while they argue that before the 10th Circuit. And the plaintiff's gonna say, okay, well, so what, that's gonna take another extra month or two? Right? And you're gonna say, yeah. Right? So I think that conversation has to be about the timing associated with that, because that's really going to affect the longevity of the case. Now, the other interesting thing is when you're talking to them, and you also heard this, I should have just kept the previous panel here. Judge Manzi, I think you should come back. You also heard that under the New Mexico Civil Rights Act, and I think it's incumbent on you probably to talk to your clients about this, both on both sides, right? Defense and plaintiffs. Look, there is not a lot of law on the New Mexico Civil Rights Act. I can tell you what I think the standard is. I heard the former speaker of the New Mexico legislature talk about it, but I'm a smart plaintiff's attorney, and maybe I think that's not the standard I want, right? And there's no decision on it. And by the way, maybe the reasonableness of my fees is going to be subject to some litigation at some point, right? I doubt it, but maybe, right? And I think the point is you've got to talk to them about time, right? Because even under the New Mexico Civil Rights Act, I think you can probably reasonably anticipate that the trial court will not be the last word if you go all the way through that process for either the defendant or the plaintiff, right? And that raises an issue that David Stout pointed out to me. So you get to the end of the trial, and it's got just this really juicy issue that would be wonderful for the appellate court to rule on, and your client doesn't want to go that way. Now, you have a conflict? Maureen says no. Why not, Maureen?
Because you don't have a choice.
You've got no choice, right? And it gets back to that same issue of client gets to decide if that's the end of the road, right? It's not the lawyer's decision, it's not a strategy decision. Can you talk to them about the prospect of an appeal? Sure. And I think you've got to talk to them about the prospect of an appeal generally, because the other side may not share their vision, but that's the end of the road. And we may be going on and up to the Court of Appeals. And then the last thing I think you're going to have to talk to about, and this is a difference, although I don't know that it's a big conversation, right? Under the New Mexico Civil Rights Act, it essentially is a municipal liability, right? Because you're suing the public body, right? And that's a very different term of art under federal Civil Rights Act, what a municipal liability claim involves. Right, so I think talking to them about that and establishing those claims are things that you're probably going to have to do. And then I think on top of all of that, you also probably have an obligation of talking about at least one other act that they might consider employing if they've been harmed by a public actor. What does that mean? The New Mexico Tort Claims Act, right? And then I think you have a whole other level of discussion there. Now, should you talk to them about bringing all three? Are any of them exclusive? Right? Can you bring a 42 U.S.C. 1983, a New Mexico Civil Rights Act, and a Tort Claims Act? Should you? What do you think? Depends. And there's one other factor that we didn't really talk about that I think you have to talk to your client about, right? Which is the venue that these are going to be litigated. At least anecdotally, right? There's a belief that if you go to federal court, that it is going to be less, and I'm not saying this is true or not true, but it's going to be less friendly to plaintiffs. In large part, the criticism has been based on the qualified immunity, right? And then the timing involved in taking it up on appeal. And in state court, who knows what the timing is going to look like, but maybe you don't have quite as hostile to the claims, or at least that's the perception. I think you've got to talk to them about that venue, and I think that affects whether you bring all three. So, whether you bring all three or not depends on a number of factors, right? It probably depends on what kind of damages you're talking about. If you have somebody who's catastrophically injured, you've got caps on both the New Mexico Tort Claims Act and a cap on the New Mexico Civil Rights Act. If qualified immunity aside, right, your venue really might need to be in federal court, because that's where you can get damages not capped. That's where you can get attorney's fees on top of it, not combined with it. And so you may have really no choice. But I think that's a conversation you have to have with the client, right? What they're getting and what they're giving up. All right, now, let's talk a little bit about conflicts. And in particular, what they asked me to talk about, which were fees, right? And so you guys are like, oh my God, it's time for cocktails, and we're going to talk about attorney's fees, and it's 4 in the afternoon. I'm doing this, right? So first off, who remembers the fee rule? I know Sophie does. 16105, right? What's sort of the watchword for attorney's fees? Reasonable? Yeah, how do you decide what's reasonable?
Market rate.
The market rate. Really? Well, now wait a minute. Wait, who said market rate? Maureen Sanders said market rate. All right. I'm glad it was
My
Maureen.
market, not yours.
Yeah, that's what I was just going to say, right? So Maureen's market rate is, I'm guessing, I don't know, $1,000 an hour?
Sure. You can
And
provide me an affidavit.
support your next fee litigation. And my market rate, what, 150 an hour? On a good day, right? So you gotta be careful with market rate, right? How do you calculate fees, right? So in Federal Civil Rights Act, there's a whole collateral piece of litigation, right? It's called fee litigation, right? You go through, plaintiff succeeds. First question you have to answer is what? Was plaintiff a prevailing party? Yeah, I mean, they recovered something. Okay, they're probably a prevailing party, maybe. And then you go through this question of how much time do they spend on it, and this whole variety of factors that go into the lodestar calculation, right? Some of which mirror 16105. 16105 in terms of reasonableness talks about what do other people in the field get paid, including people of like experience, right? And so maybe I was only partly joking, but Maureen has been doing it a little bit longer than I have. She's done a
Yeah,
lot
but
of...
I'm gonna say that I never did my own petitions. Phil Davis already did mine.
Phil Davis did. And actually, I think Phil did a lot of support for fee petitions because he had a unique feel for some of the factors, right? Including what the market would justify, the lawyer's experience, the significance of the outcome, the change in the defense position, all of those issues, right? And so if you've been doing it for a fair amount of time and your result was pretty good, and you've got that kind of reputation, your fee may be up here, right? And if you're newer to it, it's not that you're not as good, and not maybe that you got as good a result, but your fee may be a little bit lower, right? So you're looking at those same reasonableness factors. And then the question becomes, how are you recovering those fees? And it also raises, again, the possibility of a conflict for the lawyer and the client, which generally speaking is a matter of public policy. I mean, if you think about the way 16105 works, and you think about 16107, 16107 talks about if the lawyer's interests potentially have some difference between that and the client's interest, there's at least a potential for a conflict. Why is that never a question under 16105? Inevitably, if you're trying to collect fees, and inevitably if it's coming from something the client's getting, presumably that creates some friction between the two, right? Potentially a conflict. Well, as a matter of public policy, for hundreds of years now, courts have said, yeah, that's not a conflict. That's not what we're talking about. Except if you think about it in this context where there are attorney fees awarded statutorily, right? And so now potentially the conflict has arisen again. How do some of you, if you're comfortable sharing, and I don't want anybody to reveal their proprietary business information, how are some of you recovering fees? Are you relying solely on court award fees, and the court saying, Linda Danzy's work on this was worth $75,000, and yeah, she recovered $5.6 million. She gets her $75,000. The client gets the $5.6 million. Everybody goes their own way. That's one way to do it, right? Just what the court orders and awards. Other ways to do it? Yes.
I'll share. Hope this isn't wrong.
Hopefully it's not wrong. See, that's a good part of me no longer being disciplinary counsel.
Yes.
I don't know, I'm not gonna.
What I do is I'll say I'm going to take a percentage, 33 1/3 or 35% of the total, including any statutorily awarded
whichever's greater, right? So 33% out of the damages, or what the court gives me, whichever's higher.
Yeah, the whole enchilada, including fees.
The whole enchilada, okay. And I think that actually is probably the most common way, right? Which is, I'm gonna take the damages, and then we're gonna add to it whatever the court awards for fees. We're gonna put that into one giant pot for a calculator, and then I'm gonna take my percentage on top of that, off of that, right? Yeah, and I think that's the most common way to do it. What do you think justifies that? It's reasonable? Well, because you say it's reasonable? I'm not sure.
It's reasonable because you're not going to put yourself in a position where you do more work and the client gets less money.
Right, which is what you were talking about before.
Correct.
Yeah, yes.
Well, and it's inevitably, if you're taking a percentage in that context, they're taking more of your fee.
Right.
You're not-
So you're giving more up to the client in that calculation.
Right.
And I'll tell you the legal support underlying that, doing it that way, right? And actually, I think there are some lawyers who do an either or, but they don't add it in, which I don't know what you do with that extra money. That's always puzzling.
They take it.
They take it? And we'll talk about that in a minute, right? But I think what underlies that is a lot of the holdings, if you go historically, to even the U.S. Supreme Court, which has said a couple of things, right? There's the Villanueva case, which says you can recover under your agreement with the client. That's a contractual agreement with the client. We're not going to interfere with that. More importantly, what comes out of that case and others is the idea that the fees belong to the plaintiff, right? Not to the lawyer. And so if the fees belong to the plaintiff, the damages plus the fees, and then you take your contingency contract on top of that, that I think supports that, and that justification makes sense. But I want to get back to Maureen's question, yeah.
But there are some statutes that at the federal level, that courts have read that the fees actually belong to the attorneys, and there you have to be careful.
Right.
Sharing the ton of attorneys.
And the other place you have to be careful, because there's actually a reported New Mexico decision on this, right? Which is, lawyer goes, and lawyer was unaware of fee shifting, right, and fee statutes, and lawyer has contingency fee agreement, and lawyer gets the court award, and then turns to the client and says, oh, by the way, I want my 40% of your damages, or whatever the percent was, right? And lawyer ends up in trouble, and why?
Not reasonable.
I'm sorry?
Not reasonable.
Unreasonable, right? Lawyers basically doubling up the recovery, and now we're out of the situation that Sean talked about, right? Judge McAfee, right? We're talking now an unreasonable recovery, right? Because what you're doing is you're hitting the client twice, right? And now that conflict arises because you put your interest above the client's, right? Yeah, and I think you're right. I think there are some statutes that talk about if the court says this is what the attorney fee award is, that's the attorney fee award, your contingency fee contract is not going to carry the day anymore. Right? But you've got to make sure that it's written properly and that you're not ending up with double recovery under that. Now, why am I raising that? That's all federal civil rights. I mean, I think I'm raising it because it's the parallel of the New Mexico Civil Rights Act is the court in its discretion can award plaintiffs' attorney's fees. I don't think we have a decision yet or know whether the court will take more of the view, which I think is statutory, that belongs to the attorneys, as opposed to that belongs to the plaintiff. I think if it belongs to the plaintiff, writing that contingency contract the same way you write it in the Federal Civil Rights Act is probably justified, right? But if it's not, I'm going to go like this. Yes?
It says at the discretion of the court.
Right.
Do you need an order approving the fee?
Well, I think that's a good question, right? At the discretion of the court. And actually, if you read 42 U.S.C. 1988, now you're talking about the New Mexico Civil Rights Act.
Right.
But if you read 42 U.S.C. 1988, in theory, it's also discretionary, although if you follow some of the cases that have come out of it after Congress enacted 42 U.S.C. 1988, and there are plenty of circuits that certainly endorse the notion that it's required for prevailing plaintiffs, right? If you establish a prevailing party, then they get the award, right? Even though in theory it's discretionary. I think where you see the court using discretion in 42 U.S.C. 1988 is generally more on the defense side. right? Was that frivolous, was it not frivolous, right? I don't know the New Mexico Civil Rights Act. It says it's at the court's discretion. Could the court say, I don't know, it's not worth anything? Could they have to prove it? I suspect it's gonna probably be one of the first 2 or 3 to go up to the court, which is, how do you get those fees awarded? Probably by a court order, and it's probably gonna be fee litigation that takes place after the underlying judgment is entered, right? And so you're probably gonna have people like Maureen Sanders writing affidavits in support of the fees for the plaintiffs, or, well, not for the defense, because you can't get it on the defense side, yeah.
I was just going to mention that historically in New Mexico, we may have had to go to the point of writing a petition for fees, but almost universally, the plaintiffs and the defendants have sat down and settled the fees.
And settle the fees, and that's
That's
good.
okay.
And is that okay?
Yeah.
Yeah, absolutely, that's okay. Yeah, they can settle it up front, and then I think you can enter a stipulated judgment if you want a judgment, right? If you feel that you need it. I'm sorry?
I just want the check.
You just want the money. But that raises a couple, 3 other issues, and it's good that Maureen asked about those, right? So, one is, what if the, certainly I know under the Federal Civil Rights Act, there's plenty of case law, which by the way is another reason I think when you're talking to your clients, you talk to them about which act they want to use, because you know the lay of the land for the most part with Federal Civil Rights Act. I mean, we don't know the lay of the land with the New Mexico Civil Rights Act. Who knows where it's going to go, right? But what if it's a nominal damage, or it's an injunctive claim, right? The New Mexico Civil Rights Act lends itself more to damages claim, but what if it's nominal? What if it's nominal? Should you take it? And what's the court do with that fee petition? You spend $100,000 in fees to recover $100 for your client. Yes?
But that happens all the time with things like free speech cases.
With First Amendment cases,
Yeah,
yeah.
you have like a little case where somebody like is objecting to a public meeting, preventing free speech at an event. So
Right?
that's
They
not-
got kicked out of the city council meeting,
Right.
right? And so you're asking for injunctive relief.
Right, it's not, or you're asking for damages for that particular thing, but
Right.
it's not worth a lot of money, but it's still worth vindicating the person's rights.
Right?
And that's one of the reasons you have the New Mexico Civil Rights Act, for exactly that kind of thing. That's why you have attorney's fees provisions, so you can vindicate those smaller claims. So if you end up litigating for a long time, you should get your award, it's still important, but even if the damages are low.
Right. And then if the fee agreement's written the way you described it, the damages may be pretty low, but actually, you're gonna take a percentage, and it's what you said it back, right? Actually, a portion of your fees is now gonna roll over to the client under the contract that you wrote, if you litigated it to death.
No, because mine is, it's.
Oh, yours is either or. Ah, okay. So you're gonna keep the whole thing.
But I will also say though, I think that's leverage to getting them to pay your client something. Because you say, hey, I'm gonna get my fees, and that's gonna be, that's
My
where,
clock's
and
still
that's
running.
driving, that's really steering the boat. So you can say, I got you more because.
Well, now that's an interesting question. So, and I'm not gonna pick on you, maybe I am a little. Using your fees, and the clock's still running, look at that taxi meter just spinning around. Now's the time to settle. Who's that benefit? Really? The client? Probably both of you, right? But at least you have a potential for a client to say, wait a minute, I wanted to get out sooner. And your fees seem to continue to be driving this class.
But you have leverage, otherwise you have no leverage. Otherwise, why won't they could just drag their feet forever and go on and on and on and on, because they know that at the end of the day, they're gonna be paying some small amount.
Right.
You have leverage otherwise to say, no, it's not, this is worth your while, actually.
And provided that if they send in something that the client's wanting, you're willing to cut the fee, right?
Yeah.
Yeah, because then you take the conflict away. Yeah. Judge Vanzee first, and then I can.
There's a case out of the Court of Appeals under the Whistleblower Protection Act where the jury found that there was a violation of the act, but awarded 0 damages.
Right.
And the court found that the plaintiff was the prevailing party for purposes of attorney's fees. So even a 0 damage award can allow for fees.
That's true, although there's also a U.S. Supreme Court case that said the same thing, except that it said the value of the plaintiff's work on this was 0, right? So you're a prevailing party, good for you. Your value was basically nothing. We're giving you $0 in fees. So I think you run that risk, and I think I'm raising all that because I don't think we know from New Mexico yet what that shakes out to. And then the other thing is, and this is going to irritate Maureen, which is a bonus. What about you bring a claim early in the Federal Civil Rights Act now, and really what you want is injunctive relief, and maybe the damages are non-existent or they're next to nothing. And the defendant voluntarily says, nope, I'm changing. My policies have changed. I give you everything you want. Everything you want. Done. Now what? Do you get your attorney's fees?
Nope.
Why not?
Buchanan.
Buchanan, right? Anybody heard of the Buchanan case?
My entire Fed Juror class is here.
Your entire Fed Juror class. Good. Is anybody in it from here? I know there's at least one. Yeah, there's 2. Right? So Buchanan says what? It's a catalyst theory case, right? Catalyst theory case which says, used to be prior to Buchanan, and I think Buchanan was disability case? Yeah. And so the idea is, these kids in this treatment, I think it was a treatment center, are not being properly treated. The state's not doing its job. We need some change in policy. The policy gets changed. And plaintiffs' attorneys say, we need our fees. They're prevailing parties, right? Look what we got done. It's a big deal. And the U.S. Supreme Court said, there's no judicial prompter on it, right? We didn't approve it. The defendant did the right thing, and by doing the right thing, there's no prevailing party, right? Yeah, maybe you won, but you didn't really win. The catalyst theory, right, now means you don't get the fees unless somehow there's been a judicial blessing of it. Yes?
I just wanted to point out that under the Impression Public Records Act, you can get fees if all you get is records.
Right.
Or if you get the custodian to change their policy or whatever. So these fees are grafted on ICRA laws and the rights act thing. If you get some kind of injunctive relief regardless of damages, you would get fees.
Right, so in the Federal Civil Rights Act, catalyst theory is probably no longer viable, right, because of Buchanan. But I think your point is under ICRA, you can get attorney's fees for getting documents, right, and not a dime of money. And I think what that means is you're going to be arguing, right, which of these laws should we be applying to the New Mexico Civil Rights Act, right? And I think part of it's going to go back to the intent behind it, right? The idea of, and I think New Mexico historically this has been true, we tend to give a broader path for our citizens under our Constitution, sometimes in the federal Constitution. And I think at least there's a basis to argue, and I think it's a good faith argument under 16301, right? I don't think it's necessarily a frivolous argument. No, you shouldn't be looking at the Federal Civil Rights Act for the fee determination. You should be looking at other New Mexico law, because that's more consistent, and one of those is ICRA. That is a catalyst theory, right? Yeah, yes?
Well, I was just going to add the general deterrent purpose of fee shifting provisions in laws like this, but also like this, is that the fee shifting is to also be part of the fee law, other acts.
Right, so you're making a public policy argument, right? And I think you would make that public policy argument. I don't know what the answer is, right? I think courts are going to have to decide when do you get fees, when do you not get fees, when it's nominal damages, when it's injunctive, when the defendant makes the change that you asked for, and you don't get that reduced to a settlement agreement, which you then get approved by the court. And I think if you do that, right, you got something. But if not, if it's voluntarily by the defendant, I don't know. Yes?
I'm a bit concerned about the way the fee petition is written in our case.
Okay, you're concerned about the way the fee petition is written in the next draft? What in particular?
It says here's the cap, right? And fees are per individual plaintiff. But already seems to say fees, my understanding of fees as civil rights lawyer or this person, are a measure of damages that belong, not like in a more federal situation, but actual damages that belong to the person. That is another conversation. active to those fees into multiple dollars? How active is that?
Who do they belong to? Right, who do they belong to? And it kind of gets back to what we were talking about, right? Because if I understand your agreement correctly, if it was $100 to the client, $100,000 in fees that the court thinks is reasonable for you, then the $100,000 would go to you, right? And I think what I'm hearing you say is, well, wait a minute. If the court says, no, those are part of plaintiff's recovery, because our act is specifically written to say it's inclusive of fees and costs, the damage is capped, right? No, I'm sorry, we see what your contract says, but we're going to invalidate it as a matter of public policy, and we're going to give you a third or 40%, and we're giving the client the rest of that. And I think we don't know the answer to that, right? I think that's still on the horizon. You guys are going to have to litigate that, I suspect, at some point, right? And then the last thing, and I want to talk about this, right? How many of you remember because there's a question on both the defense side and the plaintiff side for this. And this is, again, Federal Civil Rights Act. I think you're going to have to litigate this under the New Mexico Civil Rights Act. And whether or not it's ethical and professional, which, by the way, yes, there's, right? Compliance with the rules of professional conduct are expected and at least set a floor. Most lawyers hopefully aspire to do more, right? A certain level of professionalism and the way they comport themselves. Anybody remember Evans versus Jeff D? Yeah, what does that case hold? This is not like, common law 101, if you're not.
Evans says that a defendant can condition a settlement on the waiver of attorney's fees.
Right? Evans says that defense can sit on the other side of the table. Now, if it's a big damages case, it's not going to probably come up, right? But we're back to those nominal damages, those cases in which it's primarily an injunctive relief, right? We want to be, I'm going to just pick on them, they're doing this now, but I'm going to pick on them, right? We want the ex-sheriff's department to start wearing body cams. And so we're bringing a claim to make that happen. No damages necessarily, I mean, set aside all the arguments of moved and right, and you have standing and all. Let's assume you can clear all those hurdles. Okay, we're gonna go ahead and get body cams, and not only that, we'll give you $500 for your trouble for your filing fees and miscellaneous costs, but conditioned on your attorney has to waive the fees completely. We're not sending in an offer that includes the $100,000 in attorney's fees that your attorney tells us they've occurred, that they've used as leverage to try to see if we can come to the table. The Evans case says what? Is that ethical? Does that meet the rules of professional conduct? Has the defendant done anything unethical? No, right? And if the plaintiff's attorney says, no, stop, you can't accept that, what's the plaintiff's attorney now just done? Created a huge conflict, right? Client gets to decide. That is basic 16-102, right? Client gets to decide whether to settle, whether to keep going forward, and the lawyer can't impose their fee as a barrier to that settlement, right? And the Supreme Court has said, yeah, that's right. Now, the second question, though, is, should a defendant be doing that? Right? So I'm litigating against Maureen Sanders, and I pick on him because I actually did litigate against them. Maureen, you won? You always did, Maureen. I'm litigating against Maureen and Judge Banzi, and it's a nominal or a non-damages case. And I send in an offer that says, well, I don't care what they want, no fees, and should, as a defendant, should I be doing that? The defendant can do it, but maybe not the defendant's lawyer? Maybe. I don't know that the rules prevent it. Certainly the U.S. Supreme Court has said that it's acceptable. It's not a rule of professional conduct violation. I think it's a real question of whether or not professionally what you're doing is driving a wedge between the plaintiff's counsel and the plaintiff. And if you look at some of the cases and the commentary that came out after the Evans case, it was pretty roundly criticized as eviscerating the concept of the private attorney general under 42 U.S.C. 1988. Again, I don't know what the answer is in the New Mexico Civil Rights Act. Would our court approve an Evans-type decision? I don't know. Maybe. Maybe not. Right? So I think that's a legitimate question. Yeah, Bob.
Under the Brody case, the defendants don't have a duty. I mean, no, the opposing party doesn't have a duty, an ethical
side, correct?
right? That's true.
Now,
You have no ethical duty to the other side.
so wouldn't that answer your question?
It answers the question of the rules of professional conduct. I don't think a defendant is going to be disciplined for sending that kind of offer in. I think there's a question of whether or not that kind of offer would be, A, professional, and B, whether our court would endorse it, right? There certainly were circuit courts, my memory is circuit courts that did not approve of that, right? And thought it was a violation of the rules because they felt essentially, for lack of a better term, that the defendants were playing unfair, right? That you owe a duty to the other side to sort of keep a level playing field, and that if you send in that kind of offer and you're manufacturing a conflict, that's a problem. I don't know exactly what rule they were trying to put that under, right? Which is maybe why the U.S. Supreme Court came up with what it did. I mean, commentators have had other reasons why they think that happened. I don't know what our Supreme Court does with that. I think that's still another open question, right? Yes?
Could you talk about the idea of a defendant making a settlement offer that's contingent on the lawyer's promise not to bring any more cases arising from that kind of incident?
Right, so there's a specific rule of professional conduct that frowns upon a lawyer either offering or agreeing to anything that would prevent them from continuing to practice. I think you would probably be at least dancing with, if not violating that rule, if that kind of offer was on the table, right? Because where you typically saw it is, it was often done, at least historically, in family law matters, right? So in family law matters, it's just nasty and contentious, and you know what? Man, I'm tired of litigating with Chanel Daniels, and if I ever see her on the other side, I'm going to have to just open a vein. And so you promise that if we resolve this today, and there's any post-decree work to be done, she won't be your lawyer, right? And courts have uniformly said you can't do that, and now there's a rule of professional conduct that says you can't. So I think, I'd have to look at how it was worded, but there's a real potential there, I think, that you could violate that rule. Yes?
I think it also was a practice that was starting to come about in product liability cases. You know, the tire company will say, we'll settle with you as long as you never bring another tire case.
Right.
And the courts have said, no can do. That's against the rules of professional conduct.
Right.
And what really happens is, if the defendant, in my experience, if the defendant starts tiptoeing towards that, I go, you know there's a rule of professional conduct that bars that, and man, they backed off at that.
Right, and the biggest issue behind it, if you think about it, is at the end of the day, clients should be able to choose who they want as their lawyer. And you shouldn't put in the defendant's hand, or in the plaintiff's hand, I suppose you could have it coming the other way, the ability to deprive somebody of the lawyer of their choice, right? So, and there's a real public policy that underscores it. So I think that would be problematic, right? Now, I think what I saw more often in practice is the offers would come in just as a chunk, right, a lump sum, and then they'd let the lawyer and the clients work out how we're going to divide that up, whether my fees have to get cut, whether it's within my contingency agreement, whatever, right? And then the defendant's not in that position of trying to drive that wedge between the two of them. But I think that's potentially an issue. And again, I don't know if Evans versus Jeff D is what New Mexico law is going to be. Maybe, right? Maybe. So I think with that, we're mostly done unless you guys have some additional questions that I'm sure I can't answer. Yes?
Yeah, coming back to the things you said at the beginning about tax man policies.
Yes.
And then I have sort of one big question about it, and try and drag this on as long as we can here, because we're right.
And by the way, so take note of why you guys are not being able to go to the cocktail.
Right, so sort of big question about that is, take the Civil Rights Act as a kind of reverse Pac-Man policy, damages cap, including fees. On the defense side, Pac-Man policies can be illegal because they're regulated by the insurance department. On the plaintiff side, is there other instances where the legislature gets to decide what type of a fee is reasonable, or is reasonableness of fees part of professional conduct rules? And then the subpart, or second part of that question is, if it's okay to regulate, are we gonna have, like the insurance regulations are, notice, and the client has to sign specific written language saying that I understand this is a package policy. Are we gonna, as plaintiffs' lawyers, or best practices to include that kind of, big, bold language, written express provisions about there being a reverse Pac-Man policy in the Civil Rights Act?
Right, so one thing I would say is it's probably not a perfect analogy. Part of why I use the Pac-Man analogy is just because conceptually, the understanding that there's an erosion of the pot, right? I think the legislature is authorized to decide if fees can be shifted, right? So you see that in the New Mexico Civil Rights Act, you see that in the Unfair Practices Act, but I think it's for the courts to determine reason, right? And I think it's court discretion, and I think you won't have the legislature, which will be a little different than in the insurance context where they get to decide reasonable, not reasonable. I think in the practice of law, and I think the Supreme Court has jealously guarded its authority to regulate the practice of law. I think they get to decide what's reasonable and not reasonable, right? The judges. I think the legislature can say, shift the fees, and we're trying to create a reason to shift the fees for public policy purposes. We want to create some incentive for people to take clients who don't have the wherewithal to follow through with this. But I think the courts get to make the decision as to how much. I do think you raise a good question, and we talked about it at the beginning, right? When you're talking to your client about where we're going to bring this, under which law, or maybe under all of them, I think that goes into a confirmation letter with the client after you're done, which says, here's what we talked about. We talked about these benefits, we talked about these risks, and you've agreed that we're going to proceed as follows, and if I misunderstand you, let me know right away, or if you really want to be belt and suspenders, please countersign this so that I'm sure we're on the same page. Now, some lawyers have said to me, well, that feels like you don't trust your client, and that's not really it, right? For most of the clients, I don't know if this is true for you, it's certainly true for the clients I dealt with. Some of them were fine when we talked, but really seeing it on paper and having more thought about it and then confirming that's what they want to do, I think that's a communication benefit for the client. It also has the beneficial effect of protecting you if they have a different memory later, yeah? And there's nothing wrong necessarily with that. I think reducing it to writing, and similar to an informed disclosure when you're getting them to conflict weight, I think you want to put that in the retainer letter as to why you chose to go the route you chose. I think one of the other things you have to talk to about them now is, look, if we take this under the New Mexico Civil Rights Act, understand nobody knows exactly what all the law is yet. We may be the ones making it up. It may come and bite us, or it may really benefit us. What else? Time for one more, Chanel said. They don't want to, they want to go eat, they're tired of listening to me. Oh wait, Bob's going to ask one more question.
So going back to the nominal damages scenario, if you figure out as the plaintiff's attorney that you're not going to get any fees.
If you figure out as the plaintiff's attorney you're not getting any fees.
And you're 75% done with the case.
Yes.
I mean, I know what I would do, but do you violate the rules if you fire the client?
You violate the rules if you fire the client because you don't think your fee's going to be big enough.
Or you want to cut your losses. And let me just preface this, that I primarily do workers' compensation law.
Right.
There is a fee cap. Half of the fee can be shifted.
Right.
Generally is paid by the work comp insurer. But one of the problems with the work comp system right now is that the fee cap, many of the cases go over the fee cap.
Right.
For both defense and workers' attorneys.
Right.
And there are a group of attorneys who will say, I'm done, I've hit 22.5, I'm not going to represent you anymore.
Right. So I can't give you specific advice, right, or become your legal advisor. What I would tell you is 16116 is the rule that pertains to withdrawal, right? There's some discussion in there about good cause. There's some discussion about unreasonable financial burden on the lawyer. I always tell lawyers to be really careful with trying to rely on unreasonable financial burden, right? Because if you made a bad business decision in taking on the representation, that's on you, not on the client. And when you start dumping the client, especially as you get further in the case and you get closer to something important, dumping the client, right, and I tell lawyers, you dump the client on the courthouse step, you're going to have a huge problem. You're going to have a disciplinary issue, you're going to have a malpractice claim, right? And if you look at the Bruin Sanders versus McKay, right, the case from...
Not me.
No, not Marine Sanders, right, the one that was down south where they withdrew, I think it was a few weeks before an arbitration. It wasn't a discipline case, it's a reported malpractice case. It was a big deal because they dumped him at the last minute. Was it for economic reasons? Was it because the case wasn't good? Whatever, right? You've got to be very careful in withdrawal, and particularly careful when you try to rely on unreasonable financial burden. I know there are a couple of reported cases because I think I was involved in them when I was in my former life with a client who told, with a lawyer who told me, I'm going to get you to point X, and then, you know, I'm going to need more money for you to keep going. And it's like, yeah, what you did is basically held a gun to your client's head and said, either you pay me more or I'm going to just dump you without a lawyer, and good luck to you, right? I think our Supreme Court will frown really heavily on that, right? Yeah. So I think the short answer is don't do that.
Okay, before everybody runs off, I have a couple of quick thank yous. First, thank you to Dean Camille Carey and the UNM administration for allowing us to be here today. Thank you to Tony Anderson, who was our tech guy that was making all the magic happen. Thank you to everybody that's on the New Mexico Law Review editorial board and staff. We are a student-run journal, so I really relied on all of my fellow students to make this event happen today. Thank you to Holly Duffy and the ACLU student organization here at UNM Law. She has really done a lot of help today and did a lot of help with our advertising. And then finally, I would like to, or not finally, but I would like to thank our planning committee, Judge Linda Vanzi, Maureen Sanders, Mark Baker, Maria Sanchez, and Carson Gordon Gonzalez for helping plan this. And finally, thank you to our three keynote speakers, Professor Joanne Schwartz, Julie Murray, and Matthew Siegel for joining us, and thank you to all of our panelists who traveled from all over New Mexico to be here with us today.